Let's go with Articles of Incorporation as a continuation, in which amendment of of Incorporation, the AOI, Articles of Incorporation, under Section 15 of the Revised Corporation Code. In stock corporation, provision or matter stated in the Articles of Incorporation may be amended. Yes, that is, in stock corporation, the Articles of Incorporation can be amended first by majority vote of board of directors, and the vote written assent or agreed of the stockholders representing at least two-thirds of the outstanding capital stock without prejudice to the appraisal right of dissenting stockholders in accordance with the provisions of this code. So that is, in order to amend the Articles of Incorporation, in case the stock corporation wants to shorten or lengthen the corporate term, so that may be one of their purpose to change the period or term of the corporate existence. They need to amend the Articles of Incorporation, in which there are two requirements that is being. First, at least majority vote of the board of directors, and a vote or written assent of the stockholders representing at least two-thirds of the outstanding capital stock. That is for stock corporation. While for non-stock corporation, may be amended may be amended by by majority vote of the trustees, majority vote of the board of trustees, and the second one is the at least two-thirds of the members. Again, for non-stock corporation, majority vote of the board of trustees, and the second one is that two-third um, at least a vote or written assent of at least two-thirds of the members. So again, for stock corporation, at least a majority vote of board of directors and at least two-thirds of vote of the um, at least two-thirds of the outstanding capital stock. And for non-stock corporation, at least majority vote of the board of trustees and at least a vote of two-thirds, a vote of at least two-thirds of the members. So that is for amending the Articles of Incorporation. While in corporate name, distinguishable, the revised corporation code requires a distinguishable corporate name, in which the revised corporation code merely requires that the corporate name must be distinguishable. In the old corporation code, or prior to the revised corporation code, the corporate name must not be identical or deceptively or confusingly similar. Those are the requirements of the prior corporation code. But when it comes to revised corporation code, um, it only requires a distinguishable corporate name. Now, as a review about kinds of corporation, wherein de jure, de facto, and estoppel corporation. When it comes to de jure corporation, it is a bona fide corporation, bona fide, that has a fulfilled requirements and granted limited liability protection under the law. So it means to say, if a corporation complies all the requirements as provided by the law, then they are granted with limited liability protection by the law, then they are called as de jure corporation. While de facto corporation is the opposite. There is an attempt, di ba? It is organized with tolerable compliance with the requirements of incorporation and allowed to exist and exercise the powers of a corporation until its existence is assailed by the state. De facto corporation, they made an attempt to comply with the requirements, but there are but there are defects. But they are allowed to exist until its existence is assailed by the state. Yes, that's de facto. De facto and de jure, wherein de jure complies all the requirements provided by the law and granted with the limited liability protection under the law. While de facto corporation, it is organized under colorable compliance with requirements of incorporation in which they made an attempt to comply with all the requirements, but there are defects. So therefore, and they are allowed to exist, and their existence is until and their existence will end until or may end until its existence may be assailed assailed by the state, when the state will question their qualifications, diba? Will question their compliance. For estoppel corporation, where incorporation by estoppel is no corporation at all, wherein it refers to someone contracting or dealing with a business as if it were a corporation. In so doing, it is an admission that the entity is a corporation and therefore estopped to deny its incorporation. Should an action arise out of the contract or course of dealing So corporation by estoppel is a corporation, is no corporation at all, and there is a misrepresentation that will allow third party to invest in it. Third parties innocently invest with that corporation, believing that they are a corporation. So therefore, there is a misrepresentation on the part of these group of persons, group of individual forming as if they are a corporation. But when it comes in suing this corporation by when it comes to filing a suit by a third party, innocent, this group of persons cannot deny the existence of the corporation. They are estopped or barred from denying it's a corporation. It cannot deny, especially third parties incurs loss or damage when they engage with this corporation or estoppel corporation because of on the ground of misrepresentation. Effects of non-use of corporate charter. Non-corporate, so this time the non-use of corporate charter and continues in operation. This is under section 21 of the revised corporation code. If we say non-use of corporate charter and continuous in operation of it, there will be a revocation. In which if a corporation does not formally organize and commence its business within 5 years from the date of its incorporation, its certificate of incorporation shall be deemed revoked as of the day following the end of the 5-year period. It means to say, example, on June 23, 2015 is the granting of certificate of incorporation. That is on June 23, 2015. Then from that day, June 23, 2015 to June 24, 2020, so it means to say there is already a period of 5 years, diba? That corporation did not formally organize and commence its business upon the date of incorporation. They were granted with the certificate of incorporation, but they did not use it. They did not commence the business within 5 years. So at the end of the 5 years, on June 24, 2020, the certificate of incorporation shall be deemed revoked. Again, if there is non-use of corporate charter or in continuous in operation from the date of incorporation up to 5 years, after 5 years of non-use or in operation, not formally organizing or commencing their business, At the end, after 5 years, the corporation, the certificate of incorporation shall be deemed revoked. Next, what if non-operation and delinquency? Non-operation and delinquency. If a corporation has commenced, its business but subsequently becomes inoperative for a period of 5 years, consecutive years. So the commission or the Securities Exchange Commission may, after due notice and hearing, place the corporation under delinquent status. So how is that? Example, on May 20, May 20, 2015, on May 20, 2015, the Securities and Exchange Commission granted that corporation with a certificate of incorporation. Then, for several months or after May, June, on June 23, 2015, ah, the same year, it commenced its business, di ba? From May 20, 2015 to June 23, 2015, it commenced its business. It starts its business. It operates. But after June 23, 2015, it becomes inoperative. And that is for 5 years. 5 years, consecutive years. It means to say, it is not staggered. It is continuous. 2015, 2016, 2017, 2018, 2019, up to 2020. And even from from January to December, there is no, or there is in operation. In operation, it did not even operate already for 5 years, consecutive years. So at the end of the 5 years, or after 5 years of inoperative, there will be a delinquent status. Delinquent status. That will be the consequence for those corporations who corporations commence for only a month, for only few months, for only a year. But after that, after the commencement, there is already a in operation. There is an in operation, non-performance or non-commencement already, or a non-continuation rather. There is no more continuation of the business for 5 consecutive years. Therefore, there will be a delinquent status. Then what's the remedy of this corporation who was granted, which was granted rather with which was granted with delinquent status. So after, di ba, from June June 23, 2015 up to June 24, 2020, for 5 years there is non-operation. So on June 24, there will be a delinquent status. So what's the remedy of this corporation? The remedy is that um, a delinquent corporation shall have a period of 2 years to resume operations and comply with all requirements that the commission shall prescribe. So 2 years shall have a 2 years. So from June 24, 2020, 2020, up to June 25, 2022, from delinquent status and count for 2 years. Within this period of 2 years, the delinquent status may be revoked. The delinquent status may be revoked, or the operation may be resumed and comply with all the requirements that the Securities and Exchange Commission shall provide. Otherwise, failure to comply the requirements within 2 years with the requirements, or failure to resume the operations within the 2-year period prescribed by the Commission, it shall cause the revocation of the delinquent corporation's certificate of incorporation. So it means to say, the remedy of a corporation who has already, which was granted with a delinquent status after 5 years of non-operation, um, After 5 years, there will be a 2-year period prescription for the corporation to comply with all the requirements and to make a resumption of the business. But failure to do that, failure to resume, failure to comply, therefore, the Securities and Exchange Commission shall revoke the certificate of incorporation. That is for non-operation and delinquency. This time, um, let's proceed with the board of directors or trustees of a corporation, qualification and term. This is now section 22 of the revised corporation code. The board of directors and or trustees of a corporation, their qualification and term. Unless otherwise provided in this code, the board of directors or trustees shall exercise corporate powers, conduct all business, and control all properties of the corporation. Again, it's the board of directors or trustees shall exercise the corporate powers, conduct all businesses, and control all properties of the corporation. Who may be a director or trustee? Who? So if any person who may be a director or trustee. This is under section 22 of the revised corporation code, in which the qualification of board of directors is that um, must own any person must own at least one share of stock. That's only the minimum requirement to become a board of director. Must own at least one subscription, one share of stock. Must own at least one share of stock, and it shall have a term of 1 year. Shall only have a 1 year from among the holders of stocks registered in the corporation's books. So the qualification of a board of directors to be a member of the board of directors must own at least one share of stock and shall have only a term of 1 year. 1 year only. While in board of trustees for non-stock corporation, must be a member only of the corporation. Must be a member of a non-stock corporation only. And also, um, a term for the trustee shall not exceed 3 years from among the members of the corporation. So it means to say shall have a term of only 3 years. For board of directors in stock corporation shall only have a 1 year. 1 year term. While for board of trustees shall have 3 years. 3-year term. After that, um, 3-year term to hold office until the successor is elected and qualified. Again, for board of directors shall only have a term of 1 year, and after the 1 year shall hold for office until successor is elected and qualified. But for board of trustees in non-stock corporation shall have a 3-year to hold office until the successor is elected and qualified. Next, corporations. What are these corporations vested with public interest? As we all know, public interest, salus populi est suprema lex, the general welfare. Ba? So what is that? Those corporations covered by the Securities Regulation Code under section 17.2 of the Securities Regulation Code. First, a corporation vested with public interest is that those corporations covered by Securities Regulation Code. Next, whose securities are registered with the Securities and Exchange Commission, publicly listed companies, or those that have registered issued shares bans the public. Again, those whose interest, corporations whose interests are registered with Securities and Exchange Commission, and companies, public listed companies, or those have registered, issued shares or banned to the public. The third is that with assets of at least 50 million pesos, 50 million pesos, and having 200 or more holders of shares with 100 shares of at least each. Again, with an asset of at least 50 million pesos, and having 200 or more holders of shares with 100 shares at least each. Next, fourth is that corporations vested with public interest, so these are already the banks, quasi-banks, non-stock savings, loan associations, pawn shops, money service business, pre-need trust, and insurance, and another financial intermediaries. So when it comes to financial intermediaries, they are already considered as corporations vested with public interest. Quasi-banks, non-stock savings and loan associations, pawn shops, pre-need insurance, pre-need trust, and money service business. And the last is that other corporations engage in businesses vested with public interest similar to number 4, wherein banks, quasi-banks, similar to that, as may be determined by the, so it is now the SEC, which will qualify if they are a corporations, or if they are a corporation vested with public interest, as determined by the SEC after taking into account relevant factors which are germane to the objective and purpose of requiring the election of an independent director. So, aside from banks, quasi-banking, pre-need plans, pre-need insurance, financial and other financial intermediaries, and those corporations that may be determined or classified by the Securities and Exchange Commission as their objective is and purpose of requiring the election of an independent director. Now, let's go with Section 23. Section 23 of the Revised Corporation Code, who should be present in the election. So, election of directors or trustees. First, who should be present during the election? First, the owners or his representatives authorized to act by written proxy. So, the owner himself or representative with written proxy. So, authorized to act by written proxy. An owner can bring his or her representative through the special power of attorney authorizing to act. Diba? The owners or his representatives authorized to act of majority, owners of majority of the outstanding capital stock must be present, di ba? You can be a director or trustees if you are a owner of at least one share of stock. And also, owners of majority of the outstanding capital stock must be present, di ba? They must be present there. They must be present. They are qualified, di ba? To be a to be members of the board to be members of the board. If no capital stock, majority of the members. Yes, that is for non-stock corporation. When so authorized in bylaws or by a majority of board of directors, the stockholders or members may also vote through remote communication or in absentia. This is one of the specialty with this revised corporation code, wherein authorized in their bylaws, in the bylaws of a corporation or in their articles of incorporation, they may stipulate by majority or even by a majority vote majority of board of directors authorized by the, there can be two ways, there can be two ways when it comes to make a remote communication or in absentia. Two ways to make, rather, I when so authorized in by the laws, when so authorized in the bylaws or by a majority of board of directors, when stipulated in bylaws or authorized by majority both of the directors, stockholders or members may also vote through remote communication or in absentia, provided that the right to vote through such modes may be exercised in corporations vested with public interest, notwithstanding the absence of a provision in the bylaws of such corporations. So again, when it comes to voting, voting for directors, voting for trustees, um, it should be, it can be in voting for board, um, it can be in communication, remote communication, or in absentia. Yes, voting already can be made in remote communication or in absentia. That's already the unique, one of the uniqueness of this revised corporation code. Voting can be made through remote communication or in absentia. But there are two requirements needed. Three. We may say three. Uh, it can be two. First, voting through remote communication if authorized by laws or by a majority board of directors. So there can be two or two. We will just make it three. First, authorized by laws, authorized by the bylaws. Next is that a majority vote of directors, a majority board of directors or trustees. And the third one is that it can only be exercised, voting through remote communication or in absentia can only be exercised by corporations vested with public interest. So again, voting through remote communication can be made if there are three, if these three, either of these three is present or is made. First, authorized by the bylaws, and or um authorized by the laws or by majority of board of directors with um can only be exercised by corporations vested with public interest. So again, authorized by laws with or by a majority board of directors, and next is that corporations vested with public interest. But remote communication, voting in through remote communication, it must be exercised only by corporations vested with public interest. The election must be in ballot if requested by any voting stockholder or member, must be in ballot. So the next will be the methods of voting. That will be for the next. Methods of voting for electing directors or trustees.